What happens when one of the biggest papers in journalism decides to throw caution into the wind and publish a reckless accusation against a former vice presidential candidate? Well, that's exactly what happened when the New York Times decided to link Sarah Palin's political action committee to a tragic mass shooting without a shred of credible evidence. The story was eventually corrected, but the damage was done, leading to a defamation lawsuit that's been dragging on for years. But this isn't just a case about hurt feelings or political grudge matches. It's a legal battle that could redefine the boundaries of freedom of speech and press responsibility in America. And let's be clear, this case is anything but straightforward. It's riddled with judicial missteps, from a judge who dismissed the case while the jury was still deliberating, to the exclusion of critical evidence that could have changed the trial's outcome. Add in the possibility that this case could eventually make its way to the Supreme Court, potentially challenging the decades-old precedent set by New York Times versus Sullivan, and you've got a legal drama that's as juicy as it is consequential. So, how did we get here? And what does this all mean for the future of defamation law? Stick around, because we're about to unpack the twists and turns of Palin's fight against one of the most powerful newspapers in the world. In June 2017, the New York Times published an editorial that linked Palin's political action committee to a horrific 2011 shooting in Tucson, Arizona, which left 6 people dead and seriously injured former Congresswoman Gabrielle Giffords. The Times claimed that there was a clear connection between Palin's campaign map, which had crosshairs over certain congressional districts, and the shooting. Except there was no such tie. No such connection actually existed. And as you might expect, Palin didn't take too kindly to being accused of inciting violence. She filed a defamation lawsuit against the Times, and thus began a legal saga that's seen more twists and turns than a daytime soap opera. The Times issued a correction, sure, but by then, the damage was done. Palin's reputation was already dragged through the mud, and she wanted her day in court. But here's the kicker. When the case finally made it to trial, the judge dismissed it, while the jury was still deliberating. Yep, you heard that right. The jury didn't even get to finish its job before the judge threw in the towel. But don't worry, the Second Circuit Court of Appeals has something to say about it, and it's not good news for the New York Times. So what exactly did the appeal court find so egregious about the way this case was handled? Buckled up, because this road ahead is full of judicial errors, questionable tactics, and a whole lot of legal drama. Imagine you're a juror, doing your civic duty, sifting through evidence in a high-profile defamation case. You're about to render your verdict when, bam, you get a push notification on your phone saying the judge has already made up their mind. How's that for undermining the integrity of the process? Well, effectively, that's what happened in the Palin case. This trial was overseen by U.S. District Judge Jed Rakoff, who in a move that can only be described as baffling, decided mid-deliberation that Palin had failed to prove actual malice. For those of you who need a quick refresher, actual malice is the legal standard that public figures like Palin typically have to meet in a defamation case. It means that proving the defamation statement was either made with knowledge that it was false or with reckless disregard for the truth. Judge Rakoff didn't just decide this behind closed doors. He dismissed the case and then, for reasons known only to him, left the jury kept deliberating. And while they were doing that, apparently some jurors got alerts on their phone about the judge's decision. The appeal court later criticized the judge for what they called improperly intruding on the province of the jury. In layman's terms, the Court of Appeals said the judge stuck his nose where it didn't belong and made a mess of the trial process. This wasn't just a procedural hiccup. The Second Circuit Court of Appeals found that Rakoff's actions undermined the jury's role as an ultimate fact finder in the case. By dismissing the lawsuit before the jury had a chance to finish deliberation, Rakoff essentially told them that their work didn't matter. The appeal court was having none of that and vacated the judgment, giving Palin another shot at justice. So what does this mean for the New York Times? Well, they're back on hook for a new trial, the 3rd time now, one where hopefully a jury, not the judge, will finally get a chance to decide if Palin was wronged. But that's just the tip of the iceberg. Let's talk about the heart of this case, the infamous editorial and the high stakes of proving actual malice. You'd think a newspaper like the New York Times would double-check their facts before making an explosive claim about a public figure inciting violence. But hey, everyone makes mistakes, right? The problem is, when the New York Times makes this kind of error, it can destroy reputations, and in this case, leads to a lawsuit that refuses to go away. As it happened, the editorial in question was published on the same day as the shooting that occurred at the congressional baseball practice that injured Representative Steve Scalise. The Times editorial board, in a rush to make a point about political rhetoric, claimed there was a clear link between Palin's campaign map and Gifford's shooting. This was a serious allegation, as it turned out, completely unfounded. James Bennett, the editorial page editor at the time, later admitted that he was the one who inserted the erroneous language about Palin. Once he realized his so-called mistake, the Times issued a correction and apology, but by then, the damage was done. Palin's legal team argued that this wasn't just a simple mistake, it was a case of actual malice. Now, actual malice is a pretty tough nut to crack, especially for public figures. It's not enough to show that the Times got it wrong. Palin has to show they knew it was wrong or acted with reckless disregard for the truth. This is where things get murky. Bennett testified that he had no intention of defaming Palin and that the error was an honest mistake. But of course, Palin's team isn't buying it. They argue that the editorial wasn't just sloppy, it was part of a broader effort to smear Palin for political purposes. But proving actual malice isn't just about what was said in the editorial. It's also about what wasn't allowed to be said in court. Let's talk about the evidence that never saw the light of day and how that might change in the retrial. Imagine fighting a legal battle with one hand tied behind your back. That's what it must have felt like for Sarah Palin during her original trial, where crucial evidence was kept from the jury. In a case where every piece of evidence could tip the scales, the exclusion of key information could be a game changer. One of the most significant issues in Palin's original trial was the exclusion of evidence that could have supported her claims of actual malice. The trial judge decided to keep certain pieces of evidence out of the courtroom, evidence the Palin team argued was essential for proving their case. For instance, there was testimony that could have shed light on editorial practices at the New York Times, including how the decision was made to publish the defamatory statements and whether there was any political motivation behind it. Bennett's own actions and his state of mind were also crucial for the case, yet much of it was kept from the jury. The Second Circuit Court of Appeals highlighted these exclusions as one of the many reasons why Palin deserves a new trial. They found that the jury should have been allowed to consider all the evidence, not just the pieces the judge deemed to be admissible. The appeal court recognized that excluding this evidence in a case this complex is one that could have unfairly tipped the scales in favor of the New York Times. The appeal court's decision to grant a new trial means all that evidence will be back on the table, giving Palin a hopefully fair shot at proving her case. This is a significant win for Palin and a setback for the New York Times, who now faces the possibility of having their dirty laundry aired in court all over again. With the evidence now back in play, the stakes are higher than ever. So what's next for Sarah Palin and the New York Times? Well, the stage is set for another trial, one in which the jury will finally get to weigh in on the evidence and decide whether the Times crossed the line. This isn't just about one woman's reputation. It's about holding the media accountable and setting the record straight. With the Second Circuit Court of Appeals setting the case back for now a third trial, we're looking at a fresh opportunity for Palin to make her case. Hopefully this time around, the jury will hear all the evidence, not just the pieces that were allowed at the first and second trials. They'll get to weigh the credibility of James Bennett and consider whether the actions amount to actual malice. The New York Times, on the other hand, will have to defend its editorial process and convince the jury that there was nothing more than an honest mistake. But with the stakes as high as ever, this time they might find that the new trial is anything but a walk in the park. If Palin wins, it could open the floodgates for other public figures to challenge media coverage of them, potentially leading to a new wave of defamation lawsuits. And if this case makes its way to the U.S. Supreme Court, which is a non-zero possibility, we could see a shift in defamation law that challenges the way about how we think about freedom of speech and responsibilities of press as it relates to public figures. We could see a fundamental shift in defamation law that changes the way we think about freedom of speech and the responsibilities of the press as it relates to public figures. One thing's for certain, this case is a case to watch. Whether you're on Team Palin or rooting for the New York Times, the outcome of this third trial will have far-reaching consequences. So stay tuned, because it appears this legal drama is just getting started. So what's the takeaway from all this? The New York Times might have thought they could have snuck in a quick correction and called it a day, but Sarah Palin had other plans. This case isn't just about defamation. It's about holding media accountable and also holding judges accountable to make sure that everyone gets a fair trial. And it's also about questioning the integrity of a supposedly elite newspaper and possibly even shaking up defamation law as you might know it. But I want to hear from you, and here's a couple questions for you to consider. First, do you think the New York Times was just an oopsies careless, or did they knowingly throw Palin under the bus to push a political narrative? Is this whole debacle a sign of the times that it might be time to rethink some of the standards of New York Times versus Sullivan, or are we opening up Pandora's box if we start messing with it? And finally, do you think judges should be allowed to play jury when they get bored of the actual one? Drop your answers in the comment section below. I'm dying to hear what you think. Until next time, I've been Uncivil Law, and remember to keep it uncivil out there.